Jefflin. Today, I'll be performing your pretrial matters, as well as the direct examination of Dr. Devin Williams and the cross-examination of Dr. Casey Rogers. May my other attorneys introduce themselves?
Yes, thank you.
Good afternoon, Your Honor. I am Sierra Bono, and I will be performing the opening statement, the cross-examination of Dakota Wires, and the direct examination of Skylar Wires.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Abby Miller, and I will be performing the direct examination of Blake Doncourt, the cross-examination of Carson Durst, as well as the closing argument. Permission for our witnesses to introduce themselves?
Yes.
Thank you, Your Honor. Good afternoon, Your Honor. My name is Ellie Hoffman, and I'll be playing the role of Dr. Devin Williams.
Good afternoon, Your Honor. I'm Curtis Anderson, and I will be playing Skylar Wires.
Good afternoon, Your Honor. My name is Layla Reyes, and I will be playing the role of Blake Doncourt.
Good afternoon, Your Honor. My name is Raven Chamberlain, and I will be today's timekeeper for Mid-Iron Grass.
Thank you. Okay, now we'll proceed to the swearing in of the team members. If you'll join by video and then raise your right hands. Okay, I think we have everyone. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? If you can say yes out loud with the microphone, please.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. And next we'll proceed to the witnesses being sworn in. If you'll join by video. Okay. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor. Yes, Your Honor.
Yes,
Yes, Your Honor. Thank you. Now we'll move to the gallery members, which includes teachers and any attorney coaches. Which I guess I don't think we have anyone in the courtroom like that since no one else is supposed to be there. So we'll move to the scoring panelists. If you'll please join by video and raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. So I think we're ready to begin unless there's any other preliminary matters by the plaintiffs or the defendants. And are there any other preliminary matters for the plaintiff?
Not at this time, Your Honor. I just want to make a quick announcement to Malachi to let him know that he's in the wrong courtroom. He's a part of our other team members. But no, the plaintiff has no more preliminary matters.
Okay, thank you for that. And are there any preliminary matters by the defense?
Yes, Your Honor. We have 5 matters to bring to the court's attention. May I continue, Your Honor?
Yes.
First of all, we'd like permission for our co-counsel to screen share exhibits on each other's behalf when it's time to screen share those exhibits.
Yes, that's granted. Do the plaintiffs have any objections to that?
We were under the understanding, Your Honor, that all exhibits have been published to opposing counsel, members of the jury, and to you, Your Honor. And we assume that screen sharing just isn't necessary, seeing as everyone has copies of the exhibits.
Could the defense explain why you want the screen sharing?
We'd like to be more clear which area of any exhibit or affidavit we're directing the scoring judges to when we speak over it. We can also direct them verbally if they've been published beforehand and they have access to them already.
Okay, I think I'm going to deny that based upon the rules that I've been given the virtual courtroom, that those exhibits are already provided. So you can move on to your second request.
Our second matter is that we'd like permission to pause the clock for any technical issues we might experience.
And can you explain what you mean by technical issues as far as if it's one of the whose problem it is?
Something like audio that scoring judges couldn't be able to hear, or a camera not being able to turn on, or accidentally leaving the meeting, or something of that sort.
I'll grant it if it's audio or a visual issue, but not if it's a matter of someone's accidentally left the meeting. And you can move on to your third issue.
Our third issue is to inform you that we're all working from the same courthouse today, and we would like to be extended time so that when we switch from computer to computer, there's one computer for the witnesses and one computer for the attorneys, that we'd be able to change our names to reflect who's actually at that computer, because we aren't using our own personal laptops.
And I'm sorry, your request is an extension of time?
Not necessarily an extension of time, just the ability to not be timed during our name changing and switching from stations.
I'm going to deny that based upon everyone was aware this was going to be a virtual courtroom during that time. In your fourth issue?
Our fourth issue is just making sure that the jury has access to all jury instructions.
I believe all of the jurors or scorers should have instructions at this point.
Our final issue is making sure that the court has access to all of its prior rulings on this case.
I'm not aware of prior rulings on this case.
There was a motion to limit damages, as well as a motion to preclude expert testimony. We just want to make sure you have access to both of those.
I'm sorry, you said it was to limit damages, and what was the second one?
To preclude expert testimony. They should both be at the front of the case.
Okay, I do not believe I have access to that.
Is it possible that we could send a PDF of the case file over with both of those attached so that you would have access to them?
I would like to make sure with the moderator that I was not already sent that or was supposed to have it. So if we want to temporarily pause, and I will check on that.
Thank you, Your Honor.
Judge Penfold, do you need assistance? This is Stacy.
All right.
Judge Penfold,
Yes, can you hear
Can
me?
you hear? Yes, yes.
Okay.
Can you hear me? Do you need any
Yes.
assistance?
Yes, there was a matter that the defense brought up that there was already a motion submitted that I should have received involving damages and expert testimony.
There's no motion submitted outside the mock trial room and unless they were in the problem. So you can address, excuse me, you can address it as an inside the bar and just rule on it. And the defense can raise their motion now.
Okay, thank you. All right.
Sorry for the delay.
Oh, no, that's no problem. Thank you. Okay, I think we are back now. Is everyone present? The defense is ready can proceed on their fifth preliminary motion. Just want to make sure everyone's back. Okay, I'm gonna deny the motion for limited damages and precluding expert testimony.
For clarification, Your Honor, we aren't raising any motions currently. We're just trying to make sure you have access to motions that the court ruled on. They're on page 4 and 5 in the case problem. I'm not sure if you have the case problem in front of you, but if you could look to those pages and let me know if you have them. That's all we're asking. We don't want any motions raised.
Yes, I don't have access to the case problem, so it's just based on your presentation. So I think if there's not anything outside of that, then we'll move on to opening statements.
All right, thank you, Your Honor.
So the plaintiff, if you want to begin with your opening statement.
Yes, Your Honor.
You can begin.
All right. Ladies and gentlemen of the jury, I represent the plaintiff, Dakota Weirs. The plaintiff is suing Lush Fertilizer for negligence on their behalf regarding their product Drufo. Allow me to tell you about Dakota Weirs, a model student and a strong member of our community. Dakota is the president of their local school government. Dakota is a part of the National Honor Society and is a student who works hard to get good grades. In what little free time Dakota had, they would volunteer at their local homeless shelter, serving meals, washing dishes, and taking part in the lives of those less fortunate than us. And above all else, Dakota was a talented and passionate musician. Ever since they were a baby, they would play the piano with their grandfather. And since their grandfather's passing at age 7, playing the piano was the only way they would stay in touch with their grandfather and keep their memory alive. Dakota started taking piano lessons in order to pursue her passion. Dakota's passion and work ethic led them to win a full ride scholarship at Juilliard in New York. However, all of this was taken from them one summer. You see, every summer, Dakota would work for a lawn care company. They would work with Lush Fertilizer products all day, every week, every month, every summer for years. All of this time spent around Lush Fertilizer led to Dakota developing non-Hodgkin's lymphoma in their early 20s. Lush Fertilizer destroyed the life of a wonderful human being, and they should be held responsible. We, the plaintiff, have the burden of proof. We will prove by a preponderance of the evidence that Lush knowingly produced a product that contained carcinogens. They were negligent. If you find that it is more likely than not that Drufo contains carcinogens and Lush Fertilizer knew about it, then you must rule in Dakota's favor. Coming to the stand today, we have Dakota Weirs, the victim of this horrible cancer. Dakota will testify to their use of Drufo and the effects of their cancer. Next, we have Dr. Casey Rogers coming to the stand to testify that Drufo does cause cancer. Dr. Rogers ran an experiment where the results concluded that Drufo was, in fact, carcinogenic. They will testify that Drufo causes cancer and will give scientific backing. Finally, we will call up Carson Durst, a scientist who worked for Lush Fertilizer for many years. Durst was part of the research and development team for Drufo. They will testify that Lush Fertilizer knew the effects of Drufo. They will testify that the CEO, Blake Doncourt, received an email about what was recommended to do in order to make Drufo safe, and yet Blake Doncourt did nothing. Carson Durst will also testify that he was in a room where concerns of Drufo being potentially carcinogenic were raised. and these concerns were then swept under the rug. These witnesses will prove by a preponderance of the evidence that Lush Fertilizer knowingly produced a product that contained carcinogens and did nothing to protect the American public. Ladies and gentlemen, two of the defense's witnesses are employees of Lush Fertilizer and are financially tied to the company. And their third witness, Skylar Weirs, has gambling debts, no college degree, and is related to the plaintiff. Blake Doncourt, the CEO of Lush Fertilizer, will claim that he had never received an email where his name was listed with the others that the email was sent to. This email was marked as highly confidential, and it was categorized in the red category. Ladies and gentlemen, Lush Fertilizer was negligent. They knowingly produced a product that contained carcinogens, and then they distributed it to the hardworking American people. They destroyed a life here today, a bright young student with a long and beautiful future ahead of them. They no longer have that future. The plaintiff would like to ask for a sum of $3 million, as we believe this justly compensates for the pain and suffering of Dakota Weirs. We will prove by a preponderance of the evidence that Lush Fertilizer was negligent with their use and production of Drufo. That will be all.
Okay, we will move to the defense. Okay, you can begin your opening statement.
Thank you, Your Honor. Proof, not possibilities. Good afternoon, Your Honor, opposing counsel, members of the jury. I am Sierra Bono, and I, along with my co-counsel, Elwood Sheffland and Abby Miller, will be representing the defense. We thank you for being here today. We are here today to determine if Lush Fertilizer is negligent in Dakota Weirs' claims. Doing so will require a preponderance of the evidence, which means that it is more likely to be true than not true. Or in other words, today we are looking for proof, not possibilities. To start today, the plaintiff will call their three witnesses to the stand: Dr. Casey Rogers, Carson Durst, and Dakota Weirs. Dr. Casey Rogers will show you a study they did that showed the possibility of cancer being more likely within farm workers than with those who worked daily with pesticides. Then Carson Durst will take the stand and tell you about a possible email they have provided that there is no proof of in Lush's database. They will also tell you about a study they showed that showed a possibility of Drufo not being safe that is yet to be proven. Finally, Dakota Weirs will take the stand and tell you how, while working with fertilizers, they chose not to wear the recommended protective gear that was recommended by both their boss and Lush Fertilizer. Then, we, the defense, will call our three witnesses to the stand: Dr. Devin Williams, Skylar Weirs, and Blake Doncourt. Dr. Devin Williams will tell you about the multitude of studies they have done that shows that Drufo is a proven safe ingredient. They will also show you how Dr. Casey Rogers' study only shows possibilities. Then Skylar Weirs will take the stand, an experienced investigative journalist. They will tell you how safe Drufo is, not only for our environment, but also for our society. Not only because it's keeping nitrates out of our water systems, but also because of the lack of dangerous chemicals there is in Lush Fertilizer products. Finally, Blake Doncourt will take the stand and tell you about how they built their company from the ground up, and how Lush Fertilizer's main goal has always been environmental safety. You will, members of the jury, you will see today that all of the studies provided by the plaintiff only show possibilities None of them have yet to be proven. We, the defense, will ask you to please look over the possibilities that the plaintiff side will provide and see the proof behind the claims and studies of the defense. Thank you.
Okay, the plaintiff may call its first witness.
Thank you, Your Honor. The plaintiff would like to call Dakota Weirs to the stand. Alrighty. Good afternoon, Mr. Weirs. Please state your name and spell the last for the record for me.
Dakota Weirs, W-E-I-R-S.
Before your illness, what did you do for a living?
Well, before the events that ended up with me here today, I worked at a landscaping company called Haven Landscaping.
And how long have you worked in landscaping?
I've been working in different capacities since I was only 14.
And outside of this work, how did you spend your free time?
I used to volunteer at my local homeless shelter, helping people who were less fortunate. I also used to play the piano.
What brings you to this courtroom today, Mr. Weirs?
I've developed non-Hodgkin's lymphoma due to my extensive work with lush fertilizer. It has ruined my life. Not only do I want to be compensated for what has happened to me, but I want to be compensated. I want compensation for others and for their misuse to end immediately.
What is your work experience with lush fertilizer?
I've worked extremely close to lush fertilizer. It was one of 4 main products we used.
And how long did you work with lush fertilizer?
Almost every day I was working. We used it very often.
Was safety equipment and clothing ever practiced in your use of lush fertilizer?
Of course it should have, but the vague warnings on the packages and from our employers were not enough for veteran landscaping in the hot sun. And we did not know the consequences, so we didn't really care.
If there were cautions about potential carcinogenic properties, what would have been done differently?
If we were told the actual consequences of what would happen if we used this unsafely, we would have been using a lot more protective gear than we were.
Do you have a sibling, Dakota?
I do, Skylar Weirs.
And how has your illness impacted your family and your sibling?
My dad has transferred the money used to pay off Skylar's crippling gambling debts from their addiction to fund my cancer treatment, and they resisted.
Has this financial shift made the relationship with Skylar difficult?
My relationship with Skylar has been better. Their gambling debts are debilitating. It's unfortunate that illness seems to be more important.
Getting back to the damages of your illness, how has the illness impacted your life?
Not only have I lost a lot of the strength to help myself or volunteer, I've also lost the ability to play the piano.
So sorry to hear that, Mr. Weirs. How has losing the piano impacted your outlook and your mental health?
At this point, I care less about my future at the Juilliard School of Music that I would have had with my scholarship. It's the fact that I can't even sit at the bench anymore.
Sorry to hear that. Where did you find this passion for piano?
I've played ever since I could walk. My grandfather taught me the basics, and piano has always been a medium for self-expression. Now, all that's left is a dusty piano and an empty seat. I had a future beyond landscaping. I could have been able to make a career out of my passion.
Tell me more about this illness. How does it impact your day-to-day life?
The illness leaves me in constant and continuous pain. It has taken away my capacity to do the things I love, and it has ripped me of my future.
Thank you, Your Honor, and thank you, Mr. Weirs. No further questions.
The defense may cross the witness.
Thank you, Your Honor. Is my timekeeper ready? Then I will proceed. Mr. Weirs, you worked at Haven Landscaping, correct?
That is correct.
And you had a boss there?
Yes, I did.
And he told you to wear a mask?
Yes, he did.
But you didn't?
Only because we didn't have the actual knowledge.
But you still didn't wear a mask?
No, I did not.
You were also told to wear long sleeves,
Yes, I was.
but you didn't.
No, because it was in the hot sun.
You were also told to wear protective pants,
Yes.
but you didn't.
No, again, because we were working in very warm conditions.
You were also supposed to wear gloves, correct?
Yes, we were.
But you didn't.
No, we were not, because again, we did not know the consequences.
At your job, you spread fertilizer, correct?
That's correct.
You also spread fertilizer in indoor places such as office buildings and malls,
Yes, we were. We did.
places that would typically have air conditioning.
Yes.
So it wouldn't have been that hot when you were spreading fertilizers indoors.
No, not exactly. But these were not all the conditions that we were exposed to. So
And you heard about Drufo through a news article, correct?
that's correct.
After which you decided on the possibility that it had caused your cancer?
We did look at
Objection, relevance. Yeah, relevance objection.
And your response, Ms. Grass?
This is extremely relevant to our case because it is the reason that we are here. It is the reason why Dakota has decided to sue Lush Fertilizer.
I'll allow it.
Would you like me to re-ask my question?
Yes, please.
After which you decided on the possibility that it caused your cancer.
Yes, because it was relevant to what I was working with.
But it hasn't been proven to have caused your cancer.
No, it has not.
After which you contacted your old boss, correct?
That's correct.
And he provided you with a label from Lush
He did.
Fertilizer that
Yes, he did.
recommended on it that you wear a mask.
Mhm.
But as previously stated, you didn't.
I did not.
So to recap, even though you were told by both Lush Fertilizer and your boss to wear a mask, you still didn't.
No, because the warnings were not significant enough, and they definitely weren't enforced.
But you were still told to. You were still told to wear a mask, but you didn't.
Yes, in a very small way.
Thank you, Your Honor. No further questions.
Does the plaintiff have any redirect?
Yes, Your Honor, briefly. Mr. Weirs, were there any substantial warnings about carcinogenic properties in your use of Lush fertilizer?
No, we're not.
In this warning label, were there any warnings of carcinogenic properties?
Only the warning to wear some sort of protective clothing. Nothing about carcinogenics.
And did anyone around you wear protective clothing?
Among us veteran workers, none of us knew the consequences, so none of us were actually wearing anything.
Thank you, Your Honor. No further questions.
Does the defense have any recross?
No, Your Honor.
Witness can step down. And the plaintiff can call their next witness.
Your Honor, the plaintiff calls Dr. Casey Rogers to the stand. Please state your name and spell your last name for the record.
Dr. Casey Rogers, Rogers.
Thank you. What is your current primary profession, Dr. Rogers?
I am currently employed as a professor in the Horticulture and Entomology Department at the University of California, Berkeley.
Thank you. What courses do you currently teach at the University of California at Berkeley?
I currently teach the Introduction to Horticultural Entomology, Horticultural Entomology, and Herbicide Selectivity and Action.
What college degrees do you hold?
I hold a Bachelor's of Science in Agriculture and Chemistry, as well as a PhD in Agriculture and Entomology.
Where did you earn these degrees?
My bachelor's came from Colorado State University, and my PhD is from UC Berkeley.
Perfect. What current projects are you working on?
Currently, I am researching in the Environmental and Chemistry Toxicology Lab, which emphasizes pesticide mode of action as well as pesticide metabolism. This information helps optimize pesticide use as well as improve their selectivity and environmental characteristics.
What did you do before your work at UC Berkeley?
I was a research analyst for a large multinational chemical company.
What has been your main focus of your research?
My main focus has been on pesticide chemistry as well as pesticide toxicology. I researched the long-term health effects of prolonged exposure to potentially harmful substances, including the chemical Drufo.
What research do you have about the impacts of chemicals?
I have a number of scholarly articles about the negative effects of prolonged exposure to various different chemicals, especially the chemical Drufo.
What has your research been used for in the past?
My research in the past has not only been used in litigation and before administrative advisory boards, but I have also made recommendations to companies and regulatory agencies on precautions that should be taken by laborers who are exposed to chemicals such as Drufo.
Dr. Rogers, will you please refer to what has been marked as Exhibit 6?
Yes, I can refer to that document.
What is this document?
This document is my curriculum vitae, and it is up to date.
Thank you. Does this document contain evidence that is not included in your prior testimony?
Yes, it does.
Now will you please direct your attention to what has been marked as Exhibit 7?
Yes, I can direct my attention to that document.
Can you please tell the court what this is?
This is a list of my research publications.
Perfect. Does this document contain evidence and information that has not been included in your previous testimony?
Yes, that is correct.
Your Honor, the plaintiff would like to request the entry of Exhibit 6 and 7 into evidence.
Objection, Your Honor. Hearsay. Both of these are documents where we haven't yet heard foundation that they're an in-court statement. And because of the fact that it's a curriculum vitae, the statement has been made out of court, developed probably over a long period of time.
Your Honor, these are business records, so that is an exception to the hearsay rule.
Exhibits 6 and 7 will be admitted into evidence.
Thank you, Your Honor. Your Honor, the plaintiff would also asks the court to qualify Dr. Casey Rogers as an expert under Rule 702 in the field of pesticides, specifically Drufo, and their impact on the human body.
Yes, we will qualify Dr. Casey Rogers as an expert.
Thank you. Dr. Rogers, what led you to do additional research on Drufo?
I decided to do additional research on Drufo because I have focused most of my career on agricultural chemicals. But Drufo caught my eye because I feel it was rushed into production without sufficient studies about its safety. I, therefore, decided to conduct my
Objection,
own
Your
study.
Honor. Narrative. Right now, we're hearing a story about the expert's life rather than data and specific testimony. I'd love for this question to be broken up into smaller pieces so that the jury could understand it more easily.
Your Honor, this is talking about her research about Drufo and based on what during her time as a scientist and through her entire career and why she decided to do more research on a chemical that is currently being questioned in court.
Your Honor, permission to respond?
Go ahead.
That doesn't stop it from being a narrative. Just because it's within the scope of your question doesn't stop that question from being something that calls for a narrative answer. Once again, I would like for this question to be broken up into smaller pieces that wouldn't be calling for narrative answers.
The objection will be sustained, and the plaintiff can continue with the questioning.
Perfect. What have you focused on mainly during your career, Dr. Rogers?
I have focused on agricultural chemicals for most of my career.
What particularly made you want to do more research about Drufo?
I feel that it was rushed into production without studies about the potential harmful effects of it.
Mm-hmm. What did you do about that, that there wasn't those studies?
I decided to conduct my own study and my own research to see if there were any adverse health effects.
All right. Did your research ever reach a conclusion?
Yes, it did. I had reason to believe that Drufo could be carcinogenic.
What made you think Drufo could be carcinogenic?
There was a study published before mine that showed that Drufo was carcinogenic in rats. So I did have reason to believe that it would be the same for humans.
All right. What did you do to test the effects of Drufo?
I created a study that followed 3 groups of people with varying and different exposures to Drufo. There was a control group, a second group with moderate exposure to Drufo, and a third group which had high and almost daily exposure to the chemical Drufo.
What were the results of this study?
I was able to find out that over a few years' time, there was an increase in health conditions, especially cancer, in people who were exposed to Drufo in comparison to the control group I previously mentioned. The study discovered that people with prolonged exposure to Drufo were 10 times more likely to be.
This is also hearsay. The witness is currently talking about the results of this study. That conclusion would be published in an out-of-court statement.
Your Honor, she is qualified as an expert, and this is her research based on Drufo, and she is an expert in pesticides and their impact on the human body.
Permission to respond, Your Honor?
Yes.
Being qualified as an expert witness is not a hearsay objection. Ultimately, regardless of whether your witness is an expert or not, it would still be hearsay because it's an out-of-court statement being brought in for the truth of the matter asserted.
The witness is answering questions regarding their research, and their research is part of their expertise.
The objection will be overruled. Proceed.
Do you mind kind of restating what were the results of this study that you completed?
Yes. So as I said, there was an increase in health conditions, particularly cancer, in people exposed to Drufo. The study discovered that people with a lot of exposure were 10 times more likely to be diagnosed with cancer than those without exposure, and 5 times more likely to be diagnosed with cancer than those with occasional or moderate exposure.
Were there any recommendations you found that would help prevent the health conditions associated with using Drufo?
Yes, I was able to find ways to mitigate the risk involved with using Drufo. The biggest thing is to wear long sleeves and long pants to make sure that the person who's using Drufo, that their skin is covered and not exposed to the chemical. Also, people using Drufo in an aerosolized version should wear a medical grade face mask like an N95.
Are there any caveats with this recommendation?
Unfortunately, yes. Many of the people who use Drufo typically do not have protective covers provided to them, and therefore the results of this part of the study were inconclusive, as there was insufficient time to study the long-term efficacy of using protective equipment.
All right. Thank you, Your Honor. No further questions.
The defense may cross the witness.
Thank you, Your Honor. Is my timekeeper ready? Wonderful. I'd like to begin now then. Now, Dr. Casey Rogers, you were retained as an expert to testify in this case. Is that correct?
Yes, I am an expert in this case.
So you were paid a retainer for your testimony today?
That is not the reason why I am here to testify.
Could you answer the question? You were paid a retainer to testify here today.
That is correct.
Now, you also hope to testify more on similar matters. Is that correct?
I do. I would like to tell people all about the negative effects of Drufo.
Wonderful. I'd like to move on to the subject of protective gear. Now, as you stated previously, you'd recommend that people would wear an N95 face mask when using Lush products.
Yes, if using an aerosolized version, wearing a medical grade face mask is a good idea.
And you would also recommend that they wear long sleeves and long pants to protect from the product.
Correct.
Now, these things aren't usually provided in agricultural jobs. Is that wrong?
No, they are not usually provided.
Wonderful. I'd like to also move on to the question of the study itself. Now, in your study, there were 3 different groups of people you were examining.
Yes, there were 3 different groups.
And one of those groups was a control, people with no exposure to the agricultural industry.
Yes.
The second group would be people with only occasional exposure.
Correct.
And the third group included farm workers?
Yes, and people with high exposure, such as someone who worked in landscaping.
Now, those people were also around other environmental factors for non-Hodgkin's lymphoma, is that correct?
Yes, but the study was focused on Drufo.
But the study didn't control for all the other variables that people would be using in an agricultural setting.
There's no way to do that.
Well, I'll bring that up later on. Now, moving on a little bit to that environmental factor specifically. Non-Hodgkin's lymphoma can be caused by any number of foreign particles. Is that correct?
Yes.
And it can also be caused by something like a pesticide.
Yes, pesticides can cause this cancer.
And farm workers would be using pesticides relatively often. Is that correct?
Yes, pesticides are common in this field of work.
Did your results account for this at all?
No, they did not.
And I'd like to move on a little bit more. You reviewed Dakota Wire's medical records.
Yes.
And you also reviewed parts of their work history.
Yes.
Now, in addition to that, you went over all of these carefully before testifying here today.
Yes.
And Dakota Wires didn't make any use of protective equipment during their career at with Lush Fertilizer.
Not that I'm aware of.
Thank you, Your Honor. No further questions.
Does the plaintiff have any redirect?
Yes, Your Honor. Dr. Rogers, why are you here today?
I am here to testify about the results of my study to show that Drufo is unsafe and carcinogenic.
Does money have anything to do with why you're testifying today?
No, not at all.
Now, with your study, is there any way, let me rephrase that. Dr. Rogers, in your study, you were focused on Drufo, correct?
Yes, that was the main focus of my study.
Is there any way to prevent other chemicals from being exposed to people in your study?
No, especially if people who work in these fields will be exposed to different pesticides.
But Drufo was the main focus.
Yes, Drufo was the main focus of my study.
And Drufo was what the people were mainly exposed to?
Yes.
No further questions, Your Honor.
Does the defense have any recross?
Yes, I would ask for a recross, Your Honor. Is my timekeeper ready? I'd begin now. Now, on the matter of the study, you said that people with occasional exposure were 5 times more likely than your control group to develop non-Hodgkin's lymphoma.
Yes.
Just to repeat one more time, you said that people with occasional exposure to that product were 5 times more likely to develop non-Hodgkin's lymphoma.
Yes, that is.
Objection, Your Honor. Relevance.
Do you have a response to the defense?
I do. Now, one of the most material issues that we're talking about here today is whether or not the product provides unreasonable risk. This study is figuring out whether this product is correlated with non-Hodgkin's lymphoma or not. Asking about this study, more specifically the results of the study, is one of the most material and relevant facts of the trial here today.
I'll overrule the objection. You can proceed.
Now, Ms. Rogers, did you write an affidavit for this case?
Yes, I did. And may I restate my answer to my previous question?
Yes.
In my study, the results suggested that it was 5 times more likely for the final group to be diagnosed with cancer than those with occasional exposure.
So you've changed that answer? Instead of the occasional exposure being 5 times more likely than the control group, it's those with daily exposure being 5 times more likely than those with occasional exposure?
Yes, I am sorry for the confusion.
So you couldn't remember the results of your own study on stand here today?
This study was quite extensive. There is a lot of information included in it.
But for the conclusion specifically, the thing that you're testifying about, whether or not this product causes cancer, you couldn't remember the specific results of that study?
I was able to recall the mistake that I made.
Thank you, Your Honor. No further questions.
The witness may step down, and the plaintiff, do you have any other witnesses?
Yes, Your Honor. The plaintiff would like to call Carson Durst to the stand.
You may proceed.
Please state your name and spell your last name for the record.
My name is Carson Durst, D-U-R-S-T.
Thank you. Where did you attend college?
I attended college with my friend Charles Darncourt at Arizona State University.
And what did you major in?
I got my bachelor's in chemical engineering.
How long have you been working with pesticides or other lawn care?
I've been working with pesticides since my employment at Lush Fertilizer in 2003.
Do you know the Darncourts?
Yes, I do.
What was your relationship with the Darncourts?
The Darncourts were like the family I never had. Charles, the son of Blake Darncourt, he was my best friend. We played soccer together as kids, and I basically became part of the family. I would go to their lake house in the summer and have dinners on Sunday. Charles and I became inseparable. The whole family was very close to me, and I love them.
Has your relationship with the Darncourts affected your job at Lush Fertilizer?
In terms of my professional career, my relationship with them did not affect my job. Even though Blake was the one who hired me, I was more than qualified for the position and I performed adequately. My relationship with them also led to the stipulation I was getting handouts from Blake and not pulling my own weight in the company, but I was performing higher than the other.
Objection, Your Honor. Narrative. May I explain my objection?
Yes.
Okay. The answer that this witness is giving is going outside the scope of the question that Mr. Sampura has asked. While it is related, it is not specifically within the scope of the question that was asked. And so I would ask that opposing counsel ask the question that they previously have, and then if they would like further information to ask an additional question. But that is why I'm objecting.
If I could respond, Your Honor.
Yes.
This question is relevant. His answer is not narrative because he is just explaining how his relationship with the Darncourts has affected his job. His relationship with them will go on. He is mentioning how it has affected his job and how people have complained about him. And he is explaining that and explaining why his relationship affected his job performance and people around him in his job.
Your Honor, if I may respond.
Yes.
I still raise this objection because some of the things such as those reviews that Mr. Durst was getting while at the job were not specifically asked for. Those were never prompted by the question asked by Mr. Sampura, and so this is still a narrative.
If I may respond, Your Honor.
Okay, this will be the last response. Go ahead.
Thank you. Him talking about his performance reviews is relevant because his performance reviews were negative because people assumed that he was not deserving of his job. This is 100% relevant, and this is 100% answering the question that I had previously asked him about his relationship with the Darncourts in relation to his job.
I'm going to sustain the objection as far as to a narrative. So if you will just break up the testimony with questions rather than having the witness speak at such length.
Okay. How long did you work for Lush Fertilizer, Mr. Durst?
I worked for Lush Fertilizer for 3 years, from 2003 to 2006.
And what did you do for Lush?
I started as an intern on the research and development team, And then after a few months, I got promoted to the product development engineer.
And what did you oversee while a product development engineer?
I oversaw the production of Drufo in fertilizer that Lush produced.
Thank you. And while you were part of the Drufo team, did you witness anything?
When I joined the company, there's an ongoing process in
Objection,
testing.
Your Honor. Ambiguous. May I please explain my objection?
Yes.
By asking if Mr. Durst observed anything in this question, Mr. Sampura is laying down a question which could be answered in a myriad of ways. This qualifies as ambiguous because it's not pointing Mr. Durst in any specific direction, but rather asking something that is broad and could be answered in a variety of ways.
Do you have any response, the plaintiff?
No, Your Honor.
I'm going to overrule the objection and you can re-ask the question.
Okay. While you were part of the Drufo team, did you witness anything regarding Drufo and the safety of Drufo?
Yes, when I joined, there was a process in testing the safety of Drufo. I was tasked with testing the safety of a particular chemical compound in Drufo and whether or not it was carcinogenic.
Thank you. Could you please take a look at Exhibit 3?
Yes, I can.
What is it?
It is an email sent out by Gary Langley.
Sorry, excuse me. Exhibit 3, not Exhibit 4. I apologize for the confusion.
Sorry, I messed up the exhibit. Permission to pull up the exhibit that I don't have.
Yeah,
Yes.
you're allowed to pull up any exhibit.
Thank you. 1 second, please. Sorry. Okay, sorry, I have it.
All right, thank you. Could you take a look at the exhibit?
Yes, I can.
What is this exhibit?
It is the conclusion of a study that was conducted about Drufo being potentially carcinogenic in rats.
Thank you. And what was this? Were you asked to look into this certain compound that was used in Drufo?
Yes, this is a compound I looked into.
Okay. Your Honor, the plaintiff would like to enter Exhibit 3 into evidence. We have provided reasons as to why it is relevant, and we would like to enter it into evidence.
We'll admit Exhibit 3 into evidence.
Objection, Your Honor. May I object on the entrance of this exhibit before it is entered?
Yes.
I am objecting on the grounds of hearsay, as this study was one not conducted in-house by Lush Fertilizer, and thus is a out-of-court statement being brought in for the truth of its matter, not produced by Lush, thus meaning that the opposing party's statement, non-hearsay response may not be used here. And so it's an out-of-court statement being brought in for the truth of the matter asserted, and it's in-house, meaning that it does not belong to a party opponent.
Thank you. If I may respond, Your Honor.
Yes, go ahead.
So according to Rule 801, subsection D, subsection 2, this is an admission by a party opponent, and therefore it is an exception to hearsay.
Your Honor, if I may respond?
Yes.
801D2, which opposing counsel has referenced, states that if something is to qualify as such, it must be a product of the party which produced it. And because this study was produced by a lab in England, not Lush Fertilizer, it does not qualify under this exception.
Permission to respond, Your Honor.
This is the last response.
This is also a business record. This is produced as a study, and we have other experiments that have been admitted into evidence previously in this courtroom. And so we have precedent to enter this as evidence based on 803 subsection 6 for business records as an exception to hearsay.
Your Honor, may I respond to the new exception which opposing counsel has brought up?
I'm going to stop us here just because I had granted that into evidence before the defense objected, and part of that might be that we're doing this virtually, but I'm going to go ahead with the admission of Exhibit 3, but I wanted you all to have a chance to explain what your reasoning were for the objections and response. So Exhibit 3 will be admitted.
Thank you, Your Honor.
May I clarify something before we continue?
We're gonna go ahead and move on because this has taken up quite a bit of time.
Okay, thank you, Your Honor.
Thank you. How did this compound affect the rats in Exhibit 3?
This compound affected the rats by the more exposure that the rats were exposed to of Drufo, then the carcinogenic effects were increased.
Thank you. Were there concerns raised about Drufo being carcinogenic?
Yes, there was a meeting where it was mentioned that the fertilizer could be carcinogenic.
Objection, Your Honor. Hearsay. May I explain my objection?
Yes.
The meeting that Mr. Durst is referencing included a scientist who was not a party of Lush Fertilizer. And this scientist is the one who stated this claim that Drufo may be carcinogenic. And so once again, this is hearsay and it is not allowed under the exception of opposing party statement, as the scientist who stated this claim was not a representative of Lush Fertilizer.
If I may respond.
Yes.
There, in nowhere in the testimony does it say that that scientist specifically was not a party of Lush Fertilizer. If you could find the place in the statement where it says that, I would be more than happy to listen, but it does not say that.
Your Honor, if I may respond one more time.
Yes.
Well, it may not say that this scientist was not a member of Lush. It never says the opposite as well. It never says that the scientist was a direct party of Lush Fertilizer, and thus we still can't qualify it under the opposing party rule or any exception under 801, the hearsay rule.
I'm sorry, Your Honor, but may I respond to just one more time?
Yeah, this is the last.
This is speculation. This was a meeting with all scientists from Lush Fertilizer all getting together to talk about Drufo. And it's impractical to say that there's no proof that he was part of Lush Fertilizer when it doesn't specifically say that this scientist was in Lush Fertilizer, when everyone else in the meeting was from Lush Fertilizer, and this was regarding specifically Drufo with people from the research and development team of Drufo.
I'm going to sustain the objection, and you can proceed.
Okay. Could you take a look at Exhibit 4, please?
Yes.
What is Exhibit 4?
It's an email sent out by Gary Langley to me, Blake Doncourt, and many other Lush Fertilizer employees.
Could you give some context to this email?
Yeah, it was a confidential email sent out, and the subject of the email was regarding the results of the most recent in-house study. It talked about the reinitiation of that study due to rising concerns about Drufo being carcinogenic.
Okay. And I would like to clarify, who was this email sent to? If you could just list off a couple of names, that would be great.
It was sent to me, Blake Doncourt, by Gary Langley, sent out by Gary Langley.
Your Honor, objection, facts not in evidence. May I explain?
Yes.
The opposing party, opposing counsel is testifying to exact things which are included in this exhibit before it has been entered into evidence. By listing names which are included in this exhibit, they violate assuming facts not in evidence, as the court has yet to admit this exhibit.
I'll sustain the objection.
All
You can go
right.
ahead.
Okay. Because Drufo was possibly carcinogenic, what should Lush Fertilizer have done?
A fellow colleague of mine recommended that baking Drufo would absolve it of any carcinogenic properties.
All right. Thank you. And when did you quit Lush Fertilizer?
I quit Lush Fertilizer in 2006.
And why did you quit?
Objection, Your Honor. Lack of foundation. May I explain?
Yes.
I'm objecting on the grounds of lack of foundation because we never received any foundational questions from opposing counsel around the quitting and, in fact, the firing of Mr. Durst from Lush Fertilizer. And so if opposing counsel would like to bring this in, they must first lay the foundation that in the first place, Mr. Durst was fired at all.
If I may respond.
Yes.
It's in the witness's statement. It's in the witness's sworn affidavit. He quit Lush Fertilizer, and yeah, I don't understand.
Your Honor, if I may respond one more time.
Yeah.
The affidavit of this witness does not qualify as foundation. In order for a proper foundation to be laid, those questions must be asked in court here today.
I'm going to sustain the objection and ask you to rephrase the question.
Okay. Do you still work for Lush Fertilizer?
I do not work for Lush Fertilizer.
When did you quit Lush Fertilizer?
I quit Lush Fertilizer in 2006.
Why did you quit Lush Fertilizer?
I just realized that it would never work well at Lush because of my personal relationship to the Don Courts. I'd always have to deal with people thinking that I was there because of my relationship to Blake Don Court and not that I was just doing my job.
Okay. Your Honor, I'm just going to go back real quick. We would like to have Exhibit 4 admitted into evidence. I understand that I'm going back a couple of questions, but we've provided evidence and context for why it should be admitted into evidence, and it is a business document because it is an email.
Admit Exhibit 4 into evidence. Okay, you can proceed.
Thank you, Your Honor. Where are you currently employed?
I'm currently working at Terra's Greenery. I've been working there since 2006.
All right. And was there a non-compete agreement signed between you, Lush Fertilizer, and Terra's Greenery when you quit to join them?
Yes, I signed it when I started my employment at Lush. However, I did not remember that I signed it, and then it came up when I left Lush and switched jobs. And then a short legal battle ensued, and the settlement that was agreed upon was that I would wait for 6 months before working at Terra's Greenery, and I did, and then the matter was resolved.
Thank you. So, one final question. Why are you speaking out against Drufo now?
Well, despite my personal connection that I had with the Don Courts, I realized that I had to speak out for what is right in order to hopefully stop more cases like Dakota's from happening. I'm sure that Lush developed a carcinogenic property and tried to cover it up by influencing their numbers. The rest of Lush could have stopped any possibility of this happening by baking the fertilizer, but decided not to.
Thank you.
Objection, Your Honor. Improper lay opinion. May I explain my objection?
Yeah, we're just, because of the sake of time, we're just going to do one response for each party.
Okay, so to explain my improper lay opinion, by stating what other members of Lush could have done to prevent carcinogenic qualities from existing in Drufo, this witness would need expert or the ability to testify as an expert, as well as the expert knowledge to know that baking Drufo would have done that. Also, by stating that their coworkers within Lush Fertilizer would have been able to do this. This is as well speculation, as we don't know that anyone at Lush either had that power or did not take the steps to make that happen.
All right, I'm gonna respond, Your Honor. According to Rule 701, the opinion testimony by lay witness, and I'm quoting from the rules of evidence here. If a witness is not testifying as an expert, the testimony in the form of opinion is limited to one that is rationally based on the witness's perception, subsection A, and B, helpful to clearly understanding the witness's testimony or to determine a fact in issue. We have proven through my questions of Durst's education and his extensive time spent around fertilizers that he is qualified to make this opinion because it is rationally based on his perception, as well as this question and his response is helpful to clearly understanding Lush Fertilizer, Drufo, and to clear up whether or not Lush Fertilizer was negligent in their production and use of Drufo.
Your Honor, may I respond as my first explanation was just the explanation of my objection?
I think we're gonna move on for the sake of time. So we're gonna overrule the objection. And I believe you said that was your final question. Is that right?
It was. Thank you, Your Honor. Thank you, Mr. Durst. The plaintiff has no further questions.
Okay. Wait, does the defense, you may proceed with the witness then.
Thank you, Your Honor. Before I begin, I would just like to clarify that my timekeeper is ready. Okay. Mr. Durst, let's start off with some of your experience with Blake and the Dawn courts. Blake was the parent of one of your childhood best friends, correct?
Yes, he was, Charles Doncourt.
And you spent extensive time with Blake because of this.
Yes.
Objection, Your Honor, relevance. I don't see how this question is relevant to understanding whether Lush Fertilizer was negligent or not.
Your Honor, if I may respond. Yes, thank you, Your Honor. Under the relevance rule, it states that anything is relevant, and that rule is 401, just for clarification. It states that something is relevant if it has the tendency to make a fact more or less probable, not qualifying what that fact should be. The point that I'm trying to make here is that for a substantial period of Mr. Durst's life, they trusted Blake and that they had a strong relationship with Blake. And so because the questions that I'm asking now make that statement and that fact more probable, it is relevant.
If I may respond one more time, Your Honor.
Okay.
That point has no relevance to the question of this case. This case is used to determine whether or not Lush Fertilizer was negligent in their production of Drufo. His relationship to Blake Doncourt and whether or not they were trusting each other or they liked each other is not relevant to this question.
I'm going to sustain the objection, so you can move forward.
Okay, I will move past my questions regarding your young life and your relationship to Blake during that time. But for a substantial period of your life, you did trust Blake, correct?
Yes, I did.
Objection, relevance. Still not relevant.
Okay,
Your Honor. Oh, I'm sorry.
He already answered the question before the objection, so you can move on to a new question.
If I could restate my answer, please.
Yes.
I did trust Doncourt, but I was a kid and he was the father of my best friend and I respected him for that. And I would just like to say that as a kid, I did trust him. However, now, after current events, I would say that I don't trust him.
Your Honor, may I respond to Mr. Simpura's response just a moment ago?
I think you can move on with your next question to the witness.
Okay. And just to clarify, Your Honor, my next questions have to do with the trusting relationship that existed here. So may I still ask these questions, or would you like me to move on to a different subject matter?
I believe, we just went over that you were going to move on to a different line of questioning, didn't we?
Oh, I'm sorry. I thought you just said to ask a different question, not to move to a different line of questioning. My apologies. So I will just move on to a different line of questioning now. Let's talk about your experience at Lush, Mr. Durst. Blake didn't care that you had no job experience when you were hired at Lush, correct?
I did have
Section
job
relevance. This is not relevant to proving whether or not Lush Fertilizer was negligent. These questions are not relevant to the question at hand of whether or not Lush Fertilizer knowingly put a carcinogen in its product Drufo and then distribute it to the American people.
And I apologize. I think my audio cut out temporarily. I didn't hear what the actual question was.
Yeah.
Okay, Your Honor, before we continue, would you just like me to re-ask that question?
Just restate the question, yes, please.
Okay. Mr. Durst, when you were brought on to the team at Lush Fertilizer, Blake didn't care that you had no experience regarding the job you were being hired for.
Objection, relevance. Still not relevant to whether or not Drufo is carcinogenic.
Do you have any response?
Yes, Your Honor, I do. Once again, under Rules of Evidence number 401, any evidence is relevant if under subsection A of 401, it has any tendency to make any fact more or less probable than it would be without the evidence, and that the fact is of the consequence in determining the action. This does not state that the question that I'm asking must be relevant to the ultimate issue within this case, but rather if it makes fact more or less true. And in this case, it does, as the point that I'm trying to make is that Mr. Durst rose through the ranks of Lush Fertilizer extremely quickly. And so the questions that I'm asking have a tendency under Rule 401 to make that fact more or less true.
Okay, well then in that case, objection, speculation. There's no proof that he rose through the ranks because of his relationship with Doncourt, and asking him questions about how close he was with Doncourt is not going to prove that.
I'm going to overrule the objection, and you can go on with your questioning.
Thank you, Your Honor. I'll go ahead and restate my question for you, Mr. Durst. When you were brought onto the team at Lush Fertilizer, Blake didn't care that you had no experience on the job, correct?
I failed to understand the question. I did have job experience. I had a bachelor's in chemical engineering.
Sure, but you didn't have any hands-on work experience, only your college degree.
Yes, but it was my first job, and
Okay.
I wouldn't have.
Thank you, Mr. Durst. That's fine. That's not the question that I'm asking. So after you were brought on as an intern, you were promoted to a full-time position, correct?
Yes, I was.
After only 3 months as an intern.
Objection, relevance. I still don't understand how this is relevant to really anything.
Your Honor, thank you. As I have previously stated, under Rule 401, any evidence is relevant if it has the tendency to make any fact more or less probable. These same questions that I'm asking are still relevant as they have the tendency to make the facts, which I'm trying to prove through my cross-examination, more or less probable.
If I could respond one more time, Your Honor. Sorry. Yeah. So under Rule 401, subsection A, it says any tendency to make a fact, right? Fact. There is no fact, there is no evidence that Mr. Durst's relationship with Blake Doncourt led to any sort of like rise in the ranks quickly. There is no fact. If what you're saying is correct, then there should be evidence and there should be facts, not just your speculation and trying to box my witness into a place.
Hey, I'm gonna sustain the objection and we need to move on. So go ahead with your question if you have any more.
Okay, I'll just move on to a different line of questioning, Your Honor. Focusing in on that internship, in 2003, you were tasked with a research assignment, correct?
Yes, I was.
And this research assignment surrounded Drufo, correct?
Yes, I did.
Okay, and it was focused on one part of this bonding agent, correct?
Yep.
Not the entire agent.
No, just one chemical compound in it.
And just to clarify for the jury, Drufo has many different components that make it up, correct?
Yes, it does.
Okay, and during your time as an intern, you only found one study on this one specific part of Drufo, correct?
Yes, I did.
Okay, and this study did not conclusively show that Drufo was carcinogenic, correct?
No, I didn't.
In rats?
I'm sorry, what was that?
Oh, it didn't conclusively show that Drufo was carcinogenic in rats?
It showed that it was possibly carcinogenic in rats.
But only possibly. Correct?
Yes.
Okay, and it also didn't show that Drufo was conclusively carcinogenic in humans, correct?
No.
Because this study never took into account humans, correct?
No, the scope of it was rats.
Okay, and there were never any follow-up studies done by the lab in England which conducted this study, correct?
No.
Objection. That question is outside the scope of this witness's testimony. It never says anywhere anything about any other studies, either A, being redone, or 2, not being replicated. This is outside of the witness's testimony. This is outside the scope of the case problem.
Your Honor, if I may respond.
Yeah, and this is it. And then I'm going to make a ruling.
Okay, under Rule of Competition 602, fact brought in that is not inside the case problem is only not allowed if it qualifies as unfair extrapolation, meaning that it is unfairly prejudicial. The question that I'm asking now, if there were any follow-up studies done in England, is not unfairly prejudicial to either side in this case, and as well by asking if there were follow-up studies done. There was no mention of studies in Mr. Durst's affidavit, as Mr. Sampura has stated, which means that there were no follow-up studies, as Mr. Durst did not reference them within their affidavit.
I'm going to sustain the objection.
I'll move on to my next question. Lush never conducted a follow-up study either, correct? Or I'm sorry, Mr. Durst, I'll restate my question. That's not what I meant to ask. Lush did conduct a follow-up study to this one in England, correct?
Objection. It never says that. Again, it's outside the scope of the witness's testimony, outside of the case. For literally the last question you asked, it's the same thing, but just with a different study.
Yeah, I'm going to sustain the objection.
Your Honor, may I respond as what Mr. Sampura is objecting to here is not the question that I asked.
I'm sustaining his objection, so we'll move on to the next question.
Okay, so in June, there was a study, or June of 2003, there was a study that came out regarding Drufo within Lush, correct?
Yes, it was an in-house study.
Okay, and around the same time, an email came out regarding Drufo, yes?
Yes, I did.
Okay. I will now ask you to reference exhibit number 4, Mr. Durst. Do you have access to exhibit number 4?
Yes, I do.
Okay, and just let me know when you have it pulled up.
Looking at it now.
Okay. Is this that email that we were just discussing?
Yes, this is that email.
Okay, but next to the categories header, this email is listed as unread, correct?
Yes.
Objection. Relevance. I don't understand why the category of the email has any relevance to any line of questioning that could even be asked in this case.
Your Honor, if I may respond.
I'm gonna, you can respond briefly, but we need to continue to move on because we're running out of time.
Okay. My response is once again referencing 401. The fact which I'm trying to prove here is that this email is what Mr. Durst cites in his concerns surrounding Drufo. And so if he never technically read this email, these concerns never could have existed. And thus this is extremely relevant.
I'm sorry, Your Honor, I'm just going to respond one more time. That's speculation. We have no idea what unread could or could not mean in this case, because most of this email is very vague as far as what the categories mean, because it also says red category. So does that mean the email was sent and it was like red colored? Because that could apply right there.
Okay, I'm going to sustain the objection and we need to continue to move on.
Okay, Mr. Durst, I'll redirect us to a different line of questioning. Still vaguely connected to the concerns that you brought up within the company. So you claim that you brought up concerns to your higher ups within Lush Fertilizer concerning different qualities that Drufo had, correct?
Yes, I did.
Okay. And these concerns you say were prompted by your higher ups, yes, and things that they had told you?
Objection, hearsay. What their higher up said has that's hearsay. She's talking about what the higher up said to him, and that's hearsay.
Your
and
Honor, if
no
I may respond.
exception.
Yeah, go ahead.
Apologies. This does not qualify as hearsay, as Mr. Durst's higher ups at the time worked for Lush Fertilizer and thus were representatives of the party, which is Lush Fertilizer. And so this qualifies under 801D2, the opposing party rule.
I'm going to sustain the objection and we'll move on.
Okay, Your Honor. I will just redirect us to a different line of questioning, Mr. Durst. And we'll go back to your relationship with Blake here. You're no longer
Objection, relevance. Still, for the same reason that the first questions about Blake were unrelevant, this is still irrelevant.
Your Honor, if I may
going back to the
respond.
questions about Mr. Doncourt because it still has no relevance.
You can briefly respond.
Okay, to start off, Your Honor, relevance is a low bar, as 401 states that anything is relevant if it has the tendency to make any fact more or less true. And the fact that I am still trying to prove here is that a relationship, a strong one, existed between Mr. Durst and Ms. Doncourt for a time, but now that relationship is not the same, which has high relevance to the case, as both are here today, and it contributes to bias, which is extremely relevant here today.
I would just like to respond. Your Honor, you already sustained my objections about relevance regarding any questions with Blake Doncourt and his relationship to Carson Durst. There is precedence set in this courtroom for my objection to be sustained. This is still irrelevant to the question and proving facts, because she's not proving facts. She is speculating about a relationship in effect with how they interacted.
I'm going to sustain the objection and reiterate again that we need to continue moving on. This is becoming, pretty tedious with the, the cross-examination on this witness. So please try to move along.
Your Honor, I'm apologies. Your Honor, are you able to hear me?
I can hear you now. I couldn't hear you for what you were just saying before now. Can you hear us now, Ms. Grass?
I can, yes. But I was unable to hear you. Could you just repeat your last ruling just so I'm clear on what you said?
I said I was sustaining the objection, but we really need to move on from, this witness. So please try to get through your questions and make it brief.
Okay, absolutely, Your Honor. I'll move on to a different line of questioning. So, Mr. Durst, you no longer work for Lush Fertilizer, correct?
No, I don't.
And instead, you now work for Terrace Greenery,
Yes, I do.
which is Lush's biggest competitor.
Yes, they are.
Okay, and during your time at Terra's, you've been tasked to a team that works specifically to develop an ingredient similar to Drufo, correct?
Objection, this is outside of the witness's testimony. The witness's testimony says that he's working on a team that has a product that is about to equal Drufo in sales as fertilizer. It never says anything about being similar to Drufo.
Your Honor, if I may respond.
Yes.
Specifically within Mr. Sampura's objection here, he said and quoted a line from Mr. Durst's affidavit stating that this competing product is about to outpace Drufo as a fertilizer. As both of these are fertilizers and ingredients within fertilizer, they are similar products.
Okay, I'll overrule the objection.
Okay, I'll go ahead and re-ask my question for you, Mr. Durst. Now that you work at Terra's, you've been tasked to work on a team that works specifically to create a product which competes with Drufo.
Yes, it does compete with Drufo, but it is not the same as Drufo.
Okay, and so essentially, though, in your current role, your job is to create a product which would outperform Drufo, yes?
Yes, that is the goal.
Objection, relevance. I don't understand. That's the objective of every person's job ever, is to outperform their competition. This makes no sense. I don't understand what she's like trying to get at here. If you could please clarify, opposing counsel.
Your Honor, if I may clarify for Mr. Sampura.
Yeah.
The point that I'm trying to make here is that by creating a product which outpaces Drufo and the fertilizers which Lush produces, this will hurt Lush Fertilizer and hurt Blake Dawncourt, which is highly relevant in this case.
I'm sorry, just to respond, I don't understand how that's relevant to this case. This case is about negligence, not about hurting Mr. Dawncourt's feelings.
I'm just going to interject here because the objections and the responses are taking up so much time. From here on out, we're going to do one objection, or the objection and then the response. I am going to sustain this objection and we need to keep moving on.
Okay. So, Mr. Durst, you were fired from Lush Fertilizer, correct?
I couldn't really hear you. Can you restate it, please?
Yeah, absolutely. You were fired from Lush Fertilizer, correct?
Yes, I was fired, but I had already started my employment at Terra's Granary.
Okay, thank you, Mr. Durst, and thank you, Your Honor. No further questions.
Objection.
I think you both are talking over each other.
Yeah, I objected to her last question before she said thank you, Your Honor.
What was your objection?
My objection was relevance. That question about being, sorry, could you please restate the question just so I can cite it correctly?
I think did the witness already answer, didn't he?
Yes, but I would just like to object.
So we're gonna move on then. So and I'm not sure where we are on time with the cross-examination. Is the timer there? Okay.
And Your Honor, we have no other witnesses that we need to cross. This, I believe, is the end of the plaintiff's case.
Okay. Did you have any redirect?
No, Your Honor, no need for a redirect.
Okay, great. All right. Well, then the witness can step down and we will move on to the defense presenting their case and they can call their first witness.
Your Honor, we would like to call Dr. Devin Williams to the stand.
Your Honor, I'm having just a moment. I'm trying to turn my camera on.
Okay.
Okay, I'm ready.
Is my timekeeper also ready? Your Honor, permission to begin?
Yes.
Please state your name and spell your last for the court.
Dr. Devin Williams, Williams.
And Dr. Williams, what do you do?
I am the lead agricultural research and development technician for the toxicology at Lush, and I'm also a professor at Colorado State University.
And do you have any education for that position?
Yes, my undergrad through my PhD is in pharmacology and toxicology at Colorado State University, and I did a post-PhD program at the University of Utah in pharmacology.
My apologies, we're having some internet issues. Your Honor, permission to re-ask that question?
Yes.
And Ms. Williams, could you speak a little bit slower? More specifically, what education did you have after attaining your master's degree? Did you hear the question, Devin Williams?
Your Honor, I can't hear my attorney's questions. I can't hear your questions. No.
I believe she said she couldn't hear your question. Do you want to try again?
Okay, I'll ask the question one more time. And just be clear if you can't hear me once again. Now, what kind of education did you get for that position?
I got specialized education within agricultural development as well as agricultural chemistry to get the position I have at Lush.
And after you finished your education, did you have any other experience?
Yes, I
Your Honor,
worked
can you hear me?
hands-on. Yes, I worked hands-on in the Lamar County's Chief Toxicology Office. I was out in the fields doing lots of hands-on work, and I got lots of work experience there.
Mr. Grass, can you hear me?
I can hear you, yes.
Okay, and I can hear the witness now, and I believe she can hear you. So were you able to hear her last response?
Yes, and I can continue on with this line of questioning.
Okay, great. Thanks.
Now, after you finished working at the Office of the Larimer County Medical Examiner, you went to Lush. What do you do there?
I work within agricultural chemistry and agricultural research and development within the toxicology fields, and I help develop and neutralize the harms of Lush's products.
Your Honor, I would like to tender this witness as an expert in the areas of agricultural development as well as toxicology.
We will recognize this witness as an expert in her field.
Now, moving on a little bit, you said you worked at Lush. What do you do there?
I work to help keep Lush as an environmentally responsible and respectful company, and I work to stop the eutrophication process.
Eutrophication? What's that?
Eutrophication is when
Objection, Your Honor. I don't see how eutrophication is relevant to the effect of Drufo on humans and causing non-Hodgkin lymphoma.
Your Honor, may I respond?
Yes.
I, like my previous attorney said, 401A states that any piece of evidence that has the tendency to make a fact more or less true as evidence is relevant. The fact that I'm trying to make more or less true is the general idea of how Lush operates. Understanding more intricately what Lush does as a company will help the jury understand what their company does reliably, what reasonable care looks like to them, what the material benefits of this case look like. And we can only get there and only understand what is material by knowing how Lush works.
I'm going to overrule the objection and you can proceed.
May I ask the question again?
Yes.
What is eutrophication?
Eutrophication is when nitrogen in the fertilizers turns into nitrates by the bacteria in soil. And then get runoff into the lake stream, and it causes algae bloom and
My apologies, Dr. William. I don't think I could hear you clearly there. I'm having some network issues. Could you restate your answer a little bit slower?
Can you repeat the question? I couldn't hear.
Did you ask if I could restate the question?
Your Honor, could you re-ask it?
I'm happy to do so. What is eutrophication? And if you could make your answer a little bit slower, it seems like fast talking might be causing the audio issues.
Yes. So eutrophication is when nitrogen from fertilizers gets turned into nitrates by bacteria in the soil, and it gets run off in lakes and streams by irrigation or runoff water, and it can cause algae blooms that kill fish and harm humans.
Now, you said Lush prevents this. How do you do that?
So Lush's products contain a bonding agent, Drufo, and it's used to bond ingredients in the fertilizer to the plants, and it stops it binds the nitrogen to the plants, and it stops the nitrates from running off, which is very key ingredient in helping eutrophication, stopping the eutrophication process.
Now, moving on from how Lush and specifically Drufo works, let's talk a little bit about its toxicology research specifically. Have you reviewed any kind of research for the impacts of Drufo on a human person?
I have reviewed numerous studies, and I have postulated their outcomes, and I have reviewed so much within toxicology research of Lush's products. It's been extensive.
What have you found based off of that time reviewing?
I have found that there's no direct correlation between Lush's products and any cause of cancer.
Well, what about Casey Rogers' study that we heard about earlier? What are your thoughts on that?
That's a very interesting question, actually. Casey Rogers' study has not been published or peer-reviewed, and I do believe their study was conducted improperly.
What do you mean by conducted improperly?
Dr. Casey Rogers' study took groups of farmers and compared them to gardeners and people who didn't do either. And there was so many other environmental impacts that the farmers could have come in contact with that it wasn't even comparing things upon the same basis. And it really just was like inconsistent with all of their test factors.
Well, how would you have conducted the study if you were the one conducting it?
I would have taken several groups of farmers and exposed them to Drufo or not exposed, just to test the effect of Drufo on humans because of the other environmental factors that Casey Rogers' study was exposed to. It was done completely improperly, and I believe if the study was conducted the way that I have described, it would have been properly given the answer that we were looking for.
Well, you say you would compare one type of farm worker not using Drufo to a type of farm worker using Drufo. Can you explain why you would do that?
I would do that because farm workers come in contact with the same things like pesticides, animal food, and like other contributing factors that could possibly cause an environmental cancer like non-Hodgkin lymphoma, so that there was no other lacks in the environmental exposure.
Your Honor, I think my witness is having technical issues again. Could we pause time pursuant to the pretrial matters?
Yes.
Thank you. One moment while we try to get that sorted out.
Sure. Okay.
Your Honor, can you hear me properly?
Yes, it's much
Okay.
clearer now.
In that case, Your Honor, may I re-ask my previous question?
Yes, and the time can resume.
Oh yeah, timekeeper, are you ready? Wonderful. Your Honor, I would like to proceed.
Yes, please move forward.
Now, you said that you would compare one type of farmer that didn't use Lush to a type of farmer that would use Lush. Why would you be doing that?
I would be doing that because we are testing on the basis of the effects of Drufo on humans. We are not testing on the basis of other environmental factors or other fertilizers that could have been used. That's just clearly not what we're here today.
Thank you, Your Honor. No further questions.
Okay, the cross-examination may begin.
All right, thank you, Your Honor. Just some questions. Do you currently work for Lush Fertilizer?
Yes, that is correct.
Okay. And you currently get paid by Lush Fertilizer?
Yes, as a working employee, I do get paid.
Thank you. Thank you. So then you would be unemployed if Lush Fertilizer went out of business.
As this is something in the future, I don't really know the outcome of this question.
Okay, that's fair. I'll move on to another one. Is it true that Drufo is banned in the European Union? A yes or no will work great. Thank you.
Yes, Drufo is banned in the European Union.
Thank you. And so Lush Fertilizer is currently attempting to get approval to sell in the EU, right?
Yes, the study that
Perfect.
the
Thank
EU
you. A yes or
conducted
no.
is
A
not
yes or no
conclusive.
will suffice, please. Thank you. Yes?
Yes.
Thank you. And so the outcome of this lawsuit would negatively affect Lush Fertilizer's attempt to get approval to sell in the EU. Is that correct?
As that is in the future, I don't really
Yes.
know. The
Oh,
outcome.
excuse me. Excuse me. Would you? I'm just going to pull up your witness statement for a second, please. Bear with me. All the way at the bottom here. All right. So I'm just going to read you line 70, or actually I'm going to read you line 69 to line 70. Okay. If we are right, Lush plans to submit our
Objection,
findings.
Your Honor. Improper impeachment.
I'm
I
sorry.
wouldn't haven't yet had a chance to restate the statement or confirm the validity of their affidavit.
I'm sorry, you were cutting out. Could you restate what you just said?
Me?
Yeah, if you don't mind. I couldn't hear what you said. You had cut out.
I'm happy to, Your Honor. I object on the ground of an improper impeachment. It seems like opposing counsel is showing my witness their affidavit, the aim of impeaching them. But first of all, my witness would need to restate their statement and the statement for the validity.
I'm not able to hear you.
And their change.
I think you might be having a little bit of trouble on your end again. I think if the timekeeper can hear me, if you want to hit pause and we'll see if we can get the technical difficulties worked out again.
I'm sorry, Your Honor. I think my audio currently cut out. I can't hear anything. using. Could you restate that ruling really quick?
I couldn't hear your objection, actually. So if you want to go ahead with that again, restate what your objection was.
I'm happy to. I objected on the grounds of an improper impeachment. It seems to me like the opposing counsel is showing my witness their affidavit in an attempt to impeach them, but within a proper impeachment, the witness must first restate the same statement that they're being impeached about and have a chance to first of all confirm that their affidavit includes all relevant information and confirm that they had the ability to change their affidavit. Before my witness has the opportunity to do either of those things, they shouldn't be impeached under the rules of competition.
If I may speak to that, I was not trying to impeach. I was merely trying to get some clarification from the witness statement. I can also restate the question before reviewing the witness statement if that would please the opposing counsel. I have no problems with that. I would just like clarification.
Your Honor, may I respond?
Yes.
In that case, I will change my objection to facts not in evidence. My witness cannot be examined based off of their affidavit. Their affidavit is not in evidence. Only the testimony that they give in court today can be made in evidence. If my attorney would like to ask a line of questioning, I would ask the opposing counsel to do that without the affidavit and instead let my witness speak for themselves.
We'll sustain the objection.
Okay, then I will re-ask the question. Is that okay?
Yeah, you can rephrase the question.
All right. Allow me to do that. Okay. So if this lawsuit went poorly for Lush Fertilizer, it would affect their attempt to get approval to sell Drufo products in the European Union. Is that correct?
Yes, there's a possibility this could happen.
Thank you. And you are the leader of the R&D toxicology team at Lush Fertilizer, right?
Yes.
I don't know if you can hear me, but I'm not able to hear you at this point in time again.
It's not. I believe speculate on. What could happen in the future?
Yeah, you
That's my
can
issue.
pause the time and try to work on your technical issues.
Your Honor, I believe our technical issue should be resolved.
Okay, great. All right. I think it's probably best if we restate what happened before the technical issues. I didn't hear anything that you had said again.
So would you like me to restate my response, Your Honor?
Yes.
Well, like I said, in the case that opposing counsel was not going for an impeachment, I would say that I would object under facts not in evidence, because the affidavit is not in evidence. The only actual testimony that is allowed to be in evidence in court today actually comes from my witness testifying on the stand, and I would ask that opposing counsel would change their question to reflect, rather than their affidavit, truly what my witness is able to testify about from their own knowledge.
Yeah, we covered that. I rephrased the question and we re-asked it before the technical problems. So thank you for bringing that up. If I may continue as to where I was, thank you. All right. You are the leader of the R&D toxicology team at Lush Fertilizer, right?
Yes, that is correct.
And is it true that breaking the fertilizer would remove even the slightest risk of carcinogens being in the final product?
This is not something that is in my area of expertise, nor something that I have studied at Lush.
Okay. And to clarify, you are qualified as an expert.
Yes.
You are qualified as an expert in toxicology. Is that right?
Yes, but baking drupa was not.
Excuse me. Yes.
Yes.
Okay. And your study of toxicology, you research and look into how the things affect humans and our systems and that sort of thing, correct?
Yes.
Okay. And yet you don't know if baking drupa would remove the risk of it being carcinogenic.
Baking drupa was outside of my research at Lush.
Even though it relates to carcinogens.
Yes, but this was never something that
thank you.
was brought up
Excuse
to
me.
in
Excuse me. Yes.
that I was
Is it just a yes or
analyzing.
no question, ma'am? It's a yes or no question.
Can you restate the question?
Of course. Even though this related to carcinogens, it was not part of your job. Is that correct?
It was not part of the studies
Okay.
I would.
Perfect.
No.
Thank you so much. So you're saying that, I'm just trying to clarify. So you're saying that you are an expert in toxicology and you do not know if baking a fertilizer would remove a risk of it being carcinogenic and deadly to humans?
Objection, Your Honor. Lack of foundation.
I'm sorry.
May I explain my objection?
I was gonna see if he was withdrawing his.
No, sorry. I started talking and I realized that I was speaking out of turn.
Okay. Yes, go ahead.
Now, so far, all that we've established is that my witness has expertise in both the workings of Lush Fertilizer during her time there and in the field of toxicology. Baking drupa specifically is not something we've seen foundation laid for the ability of my witness to testify on it. I would request that opposing counsel actually lay a foundation that my witness would have knowledge of this before he asks her to testify on it.
If I may respond, I did. I asked her if she was an expert in toxicology, and then I asked her if her work regarded, seeing how things affected humans, and that would include carcinogens, because she's an expert in toxicology. So she should understand the toxic things that can react to humans, because that is her job, and that is what her PhD is in. I have laid the foundation for my question. She should be able to answer it.
Your Honor, may I respond?
Yes.
Now, just because my witness has knowledge of toxicology doesn't mean that they would have knowledge of this one specific thing. Because of that, I will be adding a lack of personnel knowledge objection to what I've already stated. The fact of the matter is that my witness wouldn't have knowledge of this specific thing. They have knowledge of toxicology in general, and the foundation or personnel knowledge that I would be looking for is studying this specific substance. Just the general idea of toxicology and previous evidence isn't enough to reliably prove that my witness would be able to understand the toxicological context of a specific product, especially one that she has not yet studied.
If I may respond.
This is the final response.
Yeah. So toxic, I would just like to clarify what the opposing counsel is saying here. And so the opposing counsel is saying that their lead expert in toxicology cannot speak to the possibility of Drufo being carcinogenic and cannot speak to the matter of it being, of baking the product would remove would remove carcinogens from it. And I'm just trying to clarify, this is their lead toxicologist, and this is the chair of the Lush Fertilizers Ethics Committee.
We're getting off track here with the arguments within the objection. So I'm going to overrule the objection and you can proceed.
Thank you, Your Honor. All right. So, but you didn't bake the Drufo, did you?
I was not part of the production line. I was simply analyzing the research that we have done, and baking Drufo is not part of the research that I was conducting.
All right, thank you. So no?
That was not part of anything I did at Lush, no. Okay.
So you didn't have anything to do with Drufo? Is that what I'm
No, that
understand?
is not what I stated. I did not have anything to do with the baking of Drufo. That was not part of any of my job.
Okay. All right. Thank you very much. Thank you, Dr. Williams. The plaintiff has no further questions, Your Honor.
Is there any redirect?
Yes, I would like to have a redirect pursuant under 611E. Or 611D, my apologies. Is my timekeeper ready? Then I would like to begin now. Now, Dr. Devin Williams, did you ever hear about the possibility of baking Drufo?
No, this was not something I was studying or analyzing or any part of the job that I was a part of at Lush.
And did any higher-ups who have been alleged to have this information ever come to you with it?
No, it wasn't pertinent to anything.
Now, during your time at Lush, did you ever analyze Drufo in any way?
Yes, I analyzed the toxicity of it, and I analyzed the effects of it.
And your job responsibilities involving Drufo, did any of those have to do with baking specifically?
No, this is none of the responsibilities that I withheld.
Thank you, Your Honor. No further questions.
Is there any recross by the plaintiff?
No, Your Honor. Thank you.
The witness can step down and the defense can call their next witness.
Thank you, Your Honor. We call Skylar Wires to the stand.
Hello.
Before we begin, I would just like to ask the timekeeper how much time I have left for my direct. Is my judge ready?
Yes.
Then I will begin. Good afternoon, Mr. Wires. Can you please state your name and spell your last for the record?
Yeah, sure. My name is Skylar Wires, W-E-I-R-S.
What do you do for a living, Mr. Wires?
Well, I write for The Rationalist.
And do you have any other sources of income?
I do. I bet on the side, you know, Super Bowl's coming up. However, I also work at Applebee's.
And what is The Rationalist?
Oh, well, The Rationalist is a nonprofit devoted to dissuading pseudoscience and urging people to do their own research.
What kind of articles have you written for The Rationalist?
Well, I've written about all sorts of things, really. However, most recently, I have done a series on the agri-tech industry.
How long did it take you to research and write this series?
Well, for each individual article, I took about a month of research. I wrote 11 total articles, pretty much entirely devoted to research during those periods for the better part of a year.
When were these articles published?
The articles were published a couple years ago, actually before Dakota was diagnosed.
What is agritech?
Well, agritech, to put it simply, is the mixture of agriculture and technology.
How did you come about your information for your articles?
Well, I did all sorts of research. I started with going to various agritech companies' various agritech companies. Then I went to said agritech companies' sources. And finally, I went to the USDA and NASDA directly.
And what is DRUFO?
Well, DRUFO is a bonding agent added to all lush fertilizers. However, it also doubles as a pesticide.
Objection, Your Honor. This is outside of the witnesses. This is an improper lay witness opinion.
You have a response?
Yes. What DRUFO is not an opinion. It is a fact, so it's not an improper opinion.
Sorry, I meant to say an improper. The witness does not have background information, or you guys have not proven that they have the background information to for the witness to testify to that claim.
I will lay more foundation.
Go ahead.
During your series, did you write an article on DRUFO?
I did, yes.
And what is DRUFO?
Well, DRUFO, like I was about to say, is a bonding agent added to all of Lush Fertilizer's products. However, it also doubles as a pesticide. It's really interesting.
How does DRUFO connect to agritech?
Well, by definition, it is agritech. It is technologies developed for agriculture.
Your Honor, under Rule 702, I would like to qualify Skylar Wires as an expert in the field of agritech based on their level of knowledge and research.
Your Honor, the plaintiff would like to conduct a voir dire on the witness's credentials.
Do you want to conduct a voir dire on it?
Correct. Correct. May I proceed?
Yes.
Now, Mr. Weirs, are you a biologist?
No.
A chemist?
No.
A medical doctor?
I am not a medical doctor.
How about a toxicologist?
No.
Are you a scientist?
I would like to describe myself as one.
All right. Do you have a degree in toxicology?
I do not know.
Do you have a degree in agriculture?
I don't.
Do you have a medical degree?
No.
Do you have any degrees?
I do not.
All right. Your research is from the USDA and NASDA, correct?
Correct.
This is public information.
It is.
So anybody can access it?
Sure, and I encourage everyone to access it.
Thank you. Your Honor, the plaintiff objects to this witness being qualified as an expert as there is not enough foundation to qualify them, and their expertise and their credentials have not been accurately proven.
May I respond, Your Honor?
Yes.
Through this witness's testimony, they have showed that they've done an amount of research on the agritech community, as well as a series that they spent a month researching. They've also proven that they know what the agritech industry is and what DRUFO is. So I have laid the proper foundation for them to be qualified as an expert. And also under Rule 702, Mr. Wires only needs to have a level of research and knowledge to be an expert. And through his testimony, we have seen that he does.
I am not going to tender the witness as an expert, and you can continue with your line of questioning.
Can I lay more foundation to qualify them as an expert?
Yes. Oh, and I want to apologize. I will tender this witness as an expert. I misspoke. But you can continue.
Okay. Before we begin, I would like to ask you, Mr. Wires, why are you testifying in this case?
Well, as you may know, Dakota is my twin in this case, and however their diagnosis is truly terrible, all the facts show that Drufo did not cause their illness, so I have to back the science on this one.
During your research into the agritech industry, did you ever come across a company called Lush Fertilizer?
I did, and truthfully, what they're doing is very interesting.
What is Lush Fertilizer?
Well, Lush Fertilizer as a company is a, well, like I said, company developed to, it is a company that works in the agritech industry and creates fertilizer.
Has there been any controversy surrounding Lush Fertilizer?
There has. So a section of the agritech industry called the Old Guard has recently been going after Lush due to their product Drufo, which is just truly amazing. It is the biggest leap in the agritech industry since Monsanto. And it's a shame that they are the victim, that Lush is the victim of the Old Guard.
Moving on a little bit, can you tell the jury overall what fertilizers are?
Well, sure. To put it simply, fertilizers are added to a plant to produce, to benefit crop yield.
Do pesticides have any correlation to the agritech industry?
They do. They're part of the agritech industry.
And what are pesticides?
Well, pesticides by definition are poison, and they're honestly not great for anyone. However, they are applied to plants to kill like bugs and other unwanted items.
We'll come back to pesticides in a little bit. Can you refresh the jury's memory on what nitrates are?
Sure. Nitrates are the combination of nitrogen and oxygen, and they truly get everywhere.
How are nitrates bad for our environment?
Well, nitrates, they leak into groundwater and other water sources, and they cause ecological blooms, if you will, of like algae, and this causes a dead zone.
What has Drufo's impact been on nitrates?
Well, Drufo is an amazing bonding agent. So it bonds the nitrogen as well as several other chemicals in Lush fertilizer to the plant it is applied to, which means it needs to be applied less, it causes less runoff, and yeah.
Besides the fact that it's keeping nitrates out of our water system, does Drufo have any other proven benefits?
Oh yeah, absolutely. Drufo also doubles as a pesticide, which means Lush is able to take out several chemicals such as arsenic from their product. And you know, I don't think I need to be the one to tell you arsenic is not great.
And overall, what would you say about fertilizers' safety?
Well, fertilizers, as well as anything in the agritech industry, isn't 100% safe. However, Drufo is the biggest stepping stone to that safety.
Because Drufo is such a stepping stone, would you, in your expert opinion, say Lush's products are harmful?
Are harmful?
Mm-hmm.
No.
Do you have any knowledge on other chemicals your twin might have used during their time at Haven Landscaping?
I do. Over the course of the years.
Non-irrelevance. This is also improper or lack of personal knowledge on this issue.
May I respond?
Yes.
On lack of personal knowledge, this question is laying the foundation for them having knowledge of their twins' use of chemicals. And also for relevance, this is extremely relevant to the case because this is going to bring in other parts of Dakota's work experience that were harmful to his health.
I'll overrule the objection.
Would you like me to restate my question?
Yes.
Yes, please.
Did you have any knowledge on any other chemicals that Dakota used during their time at Haven Landscaping?
I did. So over the course of the years Dakota worked for Haven, they told me several things. However, they did talk about the grass seed product they laid, which contained both 2,4-D, which is a pesticide, as well as synthetic nitrogen.
And are these chemicals harmful?
Yes.
Thank you, Your Honor. No further questions.
The defense can proceed with cross-examination, or the plaintiff, excuse me.
Now, Mr. Weirs, are you a journalist?
I am.
Specifically an investigative journalist.
Yes.
You write for the Rationalist magazine?
Yes, I do write for the Rationalist.
The Rationalist magazine promotes scientific skepticism.
They promote scientific skepticism, yes.
Thank you. A yes or no do, okay. So you promote questioning scientifically proven facts.
Not scientifically proven facts, but pseudoscience.
Well, scientific skepticism is being skeptical of science, correct?
There's plenty of science out there that is quite faulty, and for instance, the science against...
Thank you. A yes or no will do. So as an investigative journalist, you are paid to do research.
I am, yeah.
You are also being paid to testify here today.
I am an expert witness, yes.
All right. We also, I was wondering, is this correct? You gamble?
I do bet on occasion, yeah.
All right. You have debts from this gambling.
I do have a slight debt. Sorry, did you hear me?
Your family has helped pay for the debts?
Yes, my family did help.
They stopped helping.
They did.
Your father has also promised to pay for Dakota's medical bills.
Yes, he has.
All right. Thank you, Your Honor. No further questions.
We're running quite short on time, and I don't want to run into the next round at 4 o'clock. So we're going to bypass the redirect and recross with this witness, and we'll move on to the next witness. So the defense can call the next witness.
Your Honor, the defense calls Ms. Blake Doncourt to the stand. And Ms. Doncourt, I'm unable to see you on my screen, but are you up and ready to go?
Yes, I am.
Okay. Please state your name and spell your last for the record.
My name is Blake Doncourt, Doncourt.
Okay, let's start off with some of your knowledge of the company Lush Fertilizer, Ms. Doncourt. Do you have knowledge of this company?
Yes, I do, actually.
And what's your relationship with the company?
I am its founder and CEO currently.
What types of products does Lush Fertilizer produce?
We produce landscaping, turf, and grass products.
All right. And who all has been known to use your products? Ms. Doncourt, were you able to hear my previous question?
Yes.
Okay. Would you like me to restate it, or are you in a place to respond?
I thought I already did respond. Do you need to?
Oh, no worries. I must have cut out on my side. I asked another question, but I'll just go ahead and restate it for you. Who all has been known to use your product?
Anywhere from landscapers to turf people to people that just want to make their grass more environmentally friendly.
Yeah, will you tell me about the work that your company has, or that you and your company have done to make Lush into the company it is today?
Yes.
Objection,
Well,
relevance. We are testifying on the kind of reputation of the company and work in that manner, when in reality we're talking about the carcinogenic properties of Drufo and its release of its product, Lush Fertilizer.
Your Honor, pursuant to your last ruling with concerns for time, may I respond or no?
Yes.
Okay. Pursuant to Rule 401, relevance is A, low bar, and B, any evidence is relevant if it has the tendency to make any fact more or less probable. Here, I'm just trying to lay the foundation that Lush is a well-built company, and as I will get into later, puts a lot of effort into making a sustainability effort in the community. So that's the point that I'm trying to bring up and lay foundation for. So these questions are relevant as they allow Ms. Doncourt to testify on these things in the future.
We're going to overrule the objection.
Okay, I'll go ahead and re-ask my question for you, Ms. Doncourt. Will you tell me about the work that it took to make Lush into the company it is today?
Well, it took many, many days and nights and sleepless hours, and I sacrificed a lot for it, but I am proud of where it has come and how it is today.
Okay, let's move on to Drufo now. How was Drufo developed within Lush Fertilizer?
Well, the formula for Drufo was developed in 2001. And then our research and development team for the product did extensive studies on it to make sure that it was the best that it could possibly be.
Okay, and is the environment a core priority within your company?
I am so glad that you asked that question. Yes, it very much is.
Have your environmental efforts been recognized at all?
Yes, they have. I believe
Objection. Character evidence, it prohibited use of character evidence. Under Rule 404A, subsection 1, evidence of a person's character or character traits such as environmental efforts or environmentalism is not admissible to prove that on a particular occasion the person acted in accordance to that character or trait.
Your Honor, if I may respond.
Yes.
The rule that Mr. McKinney is citing here talks about a person's character or character trait when I'm referencing just facts about a company, not a person, and so this can't be character evidence.
We'll overrule the objection.
Okay, I'm going to restate my question for you, Ms. Doncourt. Have these environmental efforts been recognized at all?
Yes, they in fact have. I believe it was in 2019 that Lush Fertilizer was recognized and given the Seal Business Sustainability Award. And I won't say what I was up for because it is personal, but yes, they have been.
Okay, now let's move on to the safety of Drufo. Does Lush conduct its studies regarding Drufo internally?
Yes, it very much does.
And as CEO, do you get to see these studies as they come through your company?
Yes, I do get to see these studies. I am a part of every email chain, every conversation that has to do with studying, researching, developing, and making our product Drufo as best as it can be.
Okay, and from what you've seen in your tenure as CEO, do these studies show proof or possibilities?
They show definitive proof on what Drufo is.
Okay, when you put your product on the market, was it identified as a specific risk to persons who may come in contact with it?
No, it was not.
Okay, and have you ever seen a study showing conclusively that Drufo is carcinogenic in humans?
No, I have not.
Okay, now let's move on to the labels which exist on your company's products. Was there ever a need to warn of non-Hodgkin's lymphoma on your products?
There was never a need to warn of non-Hodgkin's lymphoma or any carcinogens or cancer.
And if valid scientific studies had indicated that there were risks from using a Lush product, would you have put warning labels stating those risks on the packaging?
Not would I have only put warning labels, but I probably wouldn't have even put the product out on the market because it wouldn't be safe according to qualifying it as safe. Carcinogens aren't safe.
Okay, now let's move on to something which has been brought up in the testimony of other experts and witnesses here today, the baking process. Please explain to me what this process entails.
Well, the baking process entails putting any products such as Lush fertilizer into a very large oven and then setting it at a high temperature to then bake out any risks or harms that may be in the product.
And why did you choose not to bake your product?
I chose not to bake Drufo because there was no definitive proof within the studies conducted within Lush to show that it was needed.
Okay, Ms. Doncourt, I'll now direct your attention to exhibit number 4. Are you able to see this exhibit?
Yes.
Okay, do you recognize this exhibit?
I do not.
Okay, thank you. No further questions.
Time is up.
Okay, thank you. So if the plaintiff wants to cross-examine the witness, they can now.
Thank you, Your Honor. Good afternoon, Mrs. Doncourt. You, as you said, you considered your company a very environmentalist one, correct?
Yes, I consider it the utmost environmental.
I mean, you said it yourself in your statement that you donate 10% of your annual profit to charities to lessen the global nitrogen footprint, correct?
Yes, that is correct. I'm glad you read that.
Exactly. Yeah, it's you said you're stewards of good environmental and safety practices.
Yes.
Then surely, of course, you take every step to prevent harmful substances from being sold, as you said.
Yes, there are steps, yes.
And so you bake the product to remove even possibilities of these harmful substances from entering the environment.
Objection, Your Honor. Facts not in evidence. May I explain my objection?
Yes.
Mr. McKinney's question states that there were carcinogens or harmful things to bake out when that has A, never been proved, and B, has never been brought in to testimony here today. Because we have no proof that there were any harmful carcinogens or other harmful risks within Lush's product. This is facts not in evidence, and thus qualifies Mr. McKinney's question as such.
May I respond, Your Honor?
Yes.
I believe we're talking about possibilities here, and I think my question stated that we're the possibility. Unless I misspoke, in that case, I can obviously rephrase the question.
Okay. So
Your Honor, if I may respond. Oh,
no, we need to move on. I'll sustain the objection, and you may rephrase the question.
Thank you, Your Honor. This step would remove even the possibility of carcinogenic properties that could be in your product.
Yes, theoretically, that is what baking does.
And you had the funds to bake the product, seeing as you not have enough to spare for charitable contributions.
Yes, there were funds.
You had a team designed to catch unsafe elements of Lush fertilizer.
Yes, it was a very large team of scientists and researchers and people who cared about Drufo and making it as best as possible.
And if this team raised any concerns about the safety of your product, you would address them directly.
Yes, I would have.
And you are aware of the email sent to you by Jerry Langley, advising about
objection, Your Honor. Lack of foundation. May I explain?
Yes.
Mr. McKinney's question is asking Ms. Doncourt if she has knowledge of the email that was sent. But in my previous direct examination of Ms. Doncourt, we clarified that she does not have knowledge of such email. And so if Mr. McKinney would like to ask this question pursuant to the rule which clarifies lack of foundation, he must first lay the foundation that she received it and does have knowledge of this email.
Do you have a response?
Yes, Your Honor. I'm just asking along the lines of this evidence, whether she was aware of it at the time. I can still bring it up as it is previously entered into evidence. Whether she was aware of it at time before she's aware of it now, as it has now been entered into the courtroom. And I can now ask questions upon it.
Overruled
Your
the
Honor.
objection.
Okay, thank you.
Please examine Exhibit 4, which has been previously entered into evidence. Are you looking at this document?
Yes, I am.
Jerry Langley is one of your employees, correct?
Yes, Jerry is.
That is your name on the list of individuals that the email was sent to, correct?
Yes, it's my name, but I have no personal recollection of it.
Thank you. In the second paragraph of this email, it states, concerns have arisen regarding the generalized finding of potential carcinogenic qualities identified in the samples produced during a period early in the year, correct?
Objection, Your Honor. Rule 901, authenticating or identifying evidence. May I please explain my objection?
Briefly.
Pursuant to Rule 901, subsection A, in general, to satisfy the requirement of authenticating, which is what Mr. McKinney is trying to do, an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. As Ms. Doncourt has clarified that she doesn't know what this email is, it has not been authenticated by her, and the plaintiff has yet to lay foundation to authenticate it through them.
You have a response?
At the beginning of this problem, it does say all exhibits are authentic. But once again, this also goes to weight, not admissibility. It's not that all of these testimonies here, it goes towards weight. Whether it's admissible is up to question. Is not up to question. It has already been admitted into evidence. She can testify into this, whether it's, once again, all goes towards weight.
I'm going to overrule the objection and we'll move on.
Okay.
So you claim that you are unaware of this email, correct?
I not only claim it, but I know that I have been unaware of this email, and our email system within Lush is unaware of this email.
Thank you. It was a yes or no question. Carson Durst was fired. Who was tasked? Carson Durst was fired.
Please restate your question.
Sorry, Carson Durst was fired.
Yes, Carson was fired.
The unbaked product was released for public use.
Yes, our product was released.
No warnings about potential carcinogenic properties were provided to the customers.
Objection, Your Honor. Facts not in evidence. May I please explain my objection?
Very, very briefly.
This qualifies as facts not in evidence. As Mr. McKinney is referencing a label which has yet to be entered into evidence. It is here as exhibit number 1 today, but it has yet to be entered in as evidence by the court, and thus Mr. McKinney cannot reference it without entering it.
I'll sustain the objection.
You released the unbaked product for public use. Actually, thank you, Your Honor. No further questions.
Okay, given our lack of time, we're going to forego the direct and recross, and we will move into closing arguments, and the plaintiff may begin.
Thank you, Your Honor. Ladies and gentlemen of the jury, opposing counsel, good afternoon. Every day we are faced with choices. We choose what we like, who we spend time with, and what career or path fulfills us the most. Dakota chose that path and that fell in line with his love for piano, and his work in landscaping supported him through that. He chose to work knowing that the different products he worked with would be safe and wouldn't prevent him from pursuing his dream. He worked for every day, for weeks, for months, for years. And he worked so closely with Lush Fertilizer. Well, Lush Fertilizer had a choice too, but more importantly, they had a responsibility. They chose to knowingly release a carcinogenic product, and now Dakota lives with their decision, and he cannot choose to leave. Let's examine what our job here as the plaintiff is today. We have to prove beyond a preponderance of evidence that Lush Fertilizer produced a dangerous product and failed to warn the plaintiff, causing damages due to company negligence. Did the defendant knowingly ruin Dakota's life due to an awful and preventable illness? Well, Blake Doncourt, an avid environmentalist who would never wish harm on the environment, demonstrated that he produced the product with Truffaut, not even baking it to remove the possibility of carcinogenic properties for the sake of money. But let's not work with possibilities. Dr. Casey Rogers demonstrated that the carcinogenic risks of using Truffaut, a study that observed agricultural workers who were exposed to Truffaut correlated with an increase in the cancer, specifically non-Hodgkin lymphoma. Clearly, this isn't some one-of-a-kind issue. This is a health problem that many have experienced and Lush Fertilizer knew. It wasn't some outside private consultant making claims about carcinogenic properties. It was members of their hired team to make sure that products were safe. Carson Durst demonstrated the falsehoods produced by the company, as demonstrated in the email that most certainly passed under Blake Doncourt. Further studies were needed as there were potential carcinogenic properties that may have needed investigation. Evidence was found exposing the carcinogenic properties, and all Doncourt could do was say that it was all a hoax, a revenge for Carson Durst, who was only hired to make sure products were safe. Blake Doncourt had every motive to sweep this problem under the rug, as sacrificing dollars to safely treat the product was just simply not worth it, even though it could ruin lives, as it did. Dr. Williams had every incentive to bash the possibility of cancer. His job depended on a successful company. The company knew the risks and didn't even bake it, or simply provide a proper warning. Skylar Weirs aimed to lay out the claim that there are no carcinogenic properties. Armed with only a high school diploma, Skylar's provided the court with a demonstration of her resentment of her ill brother. Gambling debts should not be a motive for testimony. But let's get back to the damages that we're trying to quantify here. A music school opportunity, inspired by a connection with his grandfather, was cut short by an irresponsible company. Dakota has to endure the pain of a debilitating illness while also enduring the lack of accountability from a company he worked so closely with. Every day he wakes up with severe pain, swollen lymph nodes, and the psychological damage of living with a debilitating illness. The irresponsibility is simply disgusting. They chose not to bake it. They chose not to listen to their own team advising against their own team. They chose to further ignore evidence of carcinogenic properties. They simply chose wrong. We cannot go back in time and stop this terrible illness. But today, ladies and gentlemen of the jury, you do have a choice in how this ends. You each have a part to play in justice. We are asking for $3 million for Dakota, a small price to pay for someone who may not live to see 30. Choose for someone who wasn't given a choice. Choose in favor of the plaintiff. Thank you.
Okay, and now the defense may present their closing argument.
All right, and before I proceed, Your Honor, I would just like to clarify that my timekeeper is ready. Okay. Ladies and gentlemen, today we have heard the case of Dakota Weirs versus Lush Fertilizer and have been called to determine, based on proof rather than possibilities, whether or not the defendant is negligent in the claims brought against them by the plaintiff, Dakota Weirs. I would like to direct your attention to jury instruction number 2, which outlines the elements that the plaintiff must prove within this case. I'll remind you that the plaintiff has a burden of proof to meet today, and if the plaintiff fails to show proof and not possibilities for even one of these requirements, the defense's client, Lush Fertilizer, should be found not negligent on any account. Today, we saw 6 witnesses take the stand, and throughout the testimony of each, we heard proof of how only possibilities of elements 2, 3, and 4 were presented, but none were ever proved by a preponderance of the evidence. With regards to the second element, quote, the defendant was negligent by failing to exercise reasonable care to prevent the product from creating unreasonable risk of harm. This was disproved by Blake Doncourt, who explained to us that Lush's decision to not bake their product, Drufo, was based on the fact that the company had proof, not possibilities, that no carcinogens were present to bake out. The element goes on to say, quote, to persons who might have been reasonably expected to use the product in the manner the defendant might have reasonably expected. But Dakota Weir's testimony, the Through Dakota Weir's testimony, the plaintiff explained that Dakota failed to follow safety precautions recommended by both her boss and Lush Fertilizer, providing not possibilities but proof that Dakota did not fall into this group. With regard to the third element, quote, the plaintiff was one of those persons the defendant should have reasonably expected. We heard from Dakota Weir's that he was 14 when he was hired on by Hayden Landscaping, an age uncharacteristic for the job he held, meaning Dakota Wires was, quote, not one of the persons the defendant should reasonably have expected to use the product. With regards to the fourth element, which I will once again read aloud as I ask you to read along silently with me. Quote, the plaintiff had damages that were caused in the defendant's negligence. In Skylar Weir's testimony, we heard during her time at Hayden that Dakota Weir's used fertilizers produced by 4 other companies other than Lush, whose products are all known to contain carcinogens, unlike Lush's. The element goes on to state, quote, while the product is being used in a manner the defendant should have reasonably expected. And I'll remind you that Dakota was 14 on the job, disqualifying her from this group. Additionally, the defense's Dr. Devin Williams presented to us proof about the secure science around Drufo, which comes in stark contrast to the lazily researched possibilities presented by the plaintiff's Casey Rogers, who consistently forgot results of her own study while on the stand, and whose study failed to consider other environmental factors that Dakota was exposed to while on the job. Additionally, the plaintiff has attempted to prove through Carson that Drufo is carcinogenic, but they presented to us only possibilities, never any clear and indisputable proof that a study exists linking carcinogens to the uses of products containing Drufo. Additionally, Dakota himself has said here today that there was no link between their cancer and Drufo. The defense recognizes that mistakes were made during Dakota Weir's usage of Lush's product, but it is clear that these mistakes were the result of a lazy supervisor and an employee who sadly feels today the consequences of this laziness. The mistakes we should be addressing in order to seek true justice for Dakota are ones made at the hands of Hayden Landscaping, not much earlier along the supply chain at Lush Fertilizer. Members of the jury, I'll now direct your attention to page 5 of the case problem, which contains the motion to limit damages. The plaintiff has asked you to recover $3 million in non-economic damages here today, but as the jury instructions clarify for us, they may only ask for damages to be recovered if they meet their burden of proof, something they have failed to do here today by not proving elements 2, 3, and 4 within jury instruction number 2. Ladies and gentlemen, as we know, the plaintiff has provided possibilities, but has failed to show us clear, conclusive proof, meaning they have failed to meet their burden of proof here today. Through proof, it is clear that the only valid possibility to be considered here today is that of Lush Fertilizer being found not negligent on all accounts. Thank you.
We're about 5 minutes from the next session at 4, so I think we just are waiting for the scores, and they'll vote on the best witness and attorney as well, or score the best witness and attorney.
Your Honor, is there an opportunity to rebuttal with any time remaining?
It wasn't reserved. There was no rebuttal reserved, so we're going to conclude the presentations by the 2 sides and wait for the scores unless the moderator or the host needs to state something.
Thank you, Your Honor.
Thank you, Your Honor.
No, Your Honor, if both sides have rested, then we can conclude the mock trial at this point.
Okay.
Since we are running short on real time, not trial time, we will have to forego the comments by the scorers. The scorers can just complete their scores and then submit them through the form.
Great.
For the next round, we did have this isn't the only trial that was running late, so no worries. We can just we'll calculate the scores and then we'll do the next pairings. Might be running a little bit late, so just keep checking on the website.
Okay.
And